other things.
You're not wrong in that thinking, but also even when you think about the government's own anti-corruption drive, they're talking about oral recovery of loot. It takes a very monetary and fiscal element of it, but loot also extends beyond that, right? There are persons who then have taken on state assets or state capture, which might not be financial in itself, but can also be regulatory, right? The ability of persons then to have, I have put my individuals here and here in these institutions, and for which reason, for instance, when the environment is being destroyed, because we have a party person who is at the head of the institution that's supposed to take action, they have been captured by private interests or corporate interests. So that, yes, there's an expanded view of how we can talk about it, but we can also focus on the fiscal.
Yeah.
Like to see where the money goes.
I mean, because if we want to talk about each and every one, I've heard you mention not just the money, the environment. We can get into all these conversations about Galamsey and how some people are capturing or dwindling the public purse in that regard.
Exactly.
Institutions, cultural, how we don't travel. Good morning to all my Ghana people. It's not fair what they say about us, but we'll talk about that another time. But perhaps then I should say that we should limit it to our money and how we manage it and the institutions that are mandated to ensure that the monies that end up. So then we can ask the question about which institutions are mandated to protect this purse. And the purse, we've now come to agree that we are mainly talking about the monies and the loot element.
Yeah. So in the first line of protection of the public purse, in terms of the fiscal commons, perhaps you can think of it in terms of the Ghana Revenue Authority, right? They have a responsibility towards what accumulates in the consolidated fund that we're supposed to do. And many times that might be reflected in the understanding of what our tax obligations are and the extent to which they go to be able to collect that. So it's not only the expenditure part, but also the revenue generation part. Replenish comes in there. The second level then is Parliament, institutionally, which we say has control over the public purse, meaning that there can't be any fiscal spending without approval. So in the absence then of approval, or the failure of Parliament then to ensure that approval is granted or not granted for anything, that is the first line of checking whether or not this is something valuable or viable to be able to protect. When you go from Parliament, then you are then going to the implementing agencies. So the agencies to which money is disbursed have a responsibility to ensure that we are not wasteful in terms of the money that's being spent. And this is why, for instance, we might have an offense on our books which targets officials who have been involved in causing financial loss to the state. It's primarily targeted at the implementing agencies and persons who are then have a responsibility on that line. Now, when the loss has been caused, then there are institutions then that are charged with the investigation of that. And so then you have the Ghana Police Force, for instance, you have the Ghana Police Service, you have the YOCO, for instance, we have the Financial Intelligence Center, for instance, you have SHRAJ as well. Those institutions have an investigative role in unraveling how the loss occurred in terms of how the public purse can be protected. Then there's the prosecutorial element, which is primarily the Attorney General, but which has over time diffused some of the prosecutorial power and given that responsibility to the Office of the Special Prosecutor. You have the YOCO, for instance, and you have the Ghana Police Service, which serve, and now, of course, also what we call the Bureau of National, or the National Investigations Bureau, which also becomes an institution that is charged with the process of investigating and prosecuting as well.
Many have raised concerns with seeming overlaps of functions between these institutions, especially the investigative bodies and also the prosecutorial bodies. Are they actually real legally?
There is, in terms of how the state is set up, there has to be overlap institutionally across board. Now, overlap, we have to be careful of our understanding of what overlap is. Because, for instance, while the OSP has a mandate to prosecute bribery and corruption, the YOCO's responsibility goes beyond that, goes into money laundering, it goes to other areas as well. So the focus, the reason why we have different institutions is also to be able to create a better focus in terms of what each institution is doing, in the hope that they become complementary in our approach to dealing with this. The challenge comes, of course, where instead of being complementary, they become a reason for blockage and inaction. And what do I mean by this? You may have an instance, for instance, where a matter is reported to the Ghana Police Service and is reported to SHRAJ, and SHRAJ says, because the Ghana Police Service is seized of the same matter, I won't go into it. So you're going to have that become institutionally used as a mechanism of blocking. So anytime we set up this institution, it's with the expectation that they'll be collaborative in the approach. And absence of collaboration then it's more likely that they become a disservice, because then we are butting heads with each other.
So collaboratory but complementary?
Yes. So you collaborate and complement, right? And there's no prosecution that's able to go to court, or nobody can prosecute without the prior investigative work being done, right? You can't make a charging decision to charge a person with a crime unless you are certain that your investigation has been able to establish the key ingredients of a crime. So if you recall, for instance, in the Attorney General's now regular press conferences, he talks about that he's not going to go ahead and charge a person unless they are certain that they have all the ingredients settled and that they can be able to win. So that's a significant thing. It is not, we may see it as, but of course, that's how it should be, but it doesn't filter through the entirety of our criminal justice system. So many times you may have the police charge a person before court and tell the court, remand the person to give us time to investigate. It should not, in any case, make that charging decision, because it means that you are not certain that you have all the elements to be able to charge the person. Sadly, many occasions than not, particularly when the person is unrepresented, our courts will remand the person. That goes against everything that is ethical and right, because it means that you are not at the point where you should be able to even bring the person before an investigative, a judicial body.
So each of these, institutions and agencies and offices have roles to play. Let's start with the GRA. Is the GRA living up to its mandate in this case?
So I shudder to be able to say that any institution is living up to its mandate, because we have a country that is unfixed. As a pun on the fix the country.
Unfixed?
Unfixed, okay. Right? If it was fixed, the country would not exist in many respects. So, but there's no institutional perfection, we must say, right? And so in many respects, there are challenges that are institutional and administrative, and there are challenges also that are perhaps legal in many ways, because law enforcement and law itself is always chasing after crime. And so it must always be
the crime must have happened first.
Then first the crime must have happened. There will be an innovative way in which crime would happen that the law does not even contemplate when it was being made. And then you must redesign law to be able to go after it. So in that regard, you're constantly doing the chase work. But also there's also embedded practices of institutionalized corruption. I have so many clients, in my practice, where they may be faced with a tax bill, and some GRA official may call them on the backside and said, if you sorted me out with X amount, I would take care of it for you, right? So those are part of the system. And for instance, this person, and I assure you, GRA will look into it fairly, and that these persons will be dealt with. I am not aware of a single instance in that regard. So that's something that needs to be looked at. The GRA continues to give itself targets for which they are handsomely rewarded for. And so those targets tells you not that they're not necessarily designed with the thinking that economic business is growing in Ghana, and for which there's more money on the table. But it is money that we're already leaving on the table that we must make sure we improve how we get what is already being lost in that process. So yes, in that regard, the protection of the public purse,
So approvals, you mentioned to us that Parliament plays a key role.
Yeah.
So where has Parliament missed the boat? Because we see these conversations, these debates happen on the floor of Parliament, and more often than not, there appears to be some approval given to, the disbursement of some of these funds.
So let's think about, before I come to the disbursement aspects of Parliament's role, well, you have to remember that Parliament also, it goes to the point where the extent to which a lot of these loans never fail in Parliament. Parliament was being
always approve
it was ushered through the certificate of urgency, that we're over getting into, unsustainable debt. So the fact that unsustainable debt exists tells you that the check that was supposed to be on the executive in terms of not indebting the country had not been performed fully. So that's the first, I suppose, failure in some regard. And I know that in the conversations around the Constitution review, the question of debt is a big part of the conversation as to whether or not, because Parliament has not been effective in checking debt, can there be a mechanism? For instance, we made a proposal about certain debt deals needed to be referendum. Whether or not we go into the IMF needs to go to the referendum.
The citizens must
have a say. So how then do we bring citizens into the process for them then to become the check when Parliament fails us in that regard? Then there's also the expenditure problem. That in many instances, the classic case of expenditure problem is how the National Cathedral got built, right? Or, unbuilt, approved discretionary funds to the executive. Discretionary funds that it was so much that we were able to then carry chunks of it to then go into a vanity project like that. That tells you that we have to be even more rigorous in terms of how much money we allow
in the discretionary
in the collar market. That some of the people went to the office of the president to go and commiserate, and funds were released to them. It was reported by the press, 1 million cedis. But the funds was released in cash. And I asked myself, how is the presidency dealing in cash to that level? There's so much funds that are spent at the presidency level, for instance, that are done in cash.
And this is across administration, not just in one.
Yes. This is an auditing nightmare to be handling that level of cash which is not going through the banking system. But also, if you look across administrations, so much money is spent for which approval has not been given, and it's taken later to Parliament to ratify. So overrunning of the budget tells me that there's a problem. If you follow the US politics, for instance, there are many instances where they say we have a government shutdown. A government shutdown means that the government, money has not been approved. And so government cannot spend. They can't pay salaries. And you must stay because Parliament must first approve. In our case, we spend it anyway when the Parliament has approved, knowing that Parliament will ratify it. Meaning that element then of being a control over the expenditure has lost its relevance because it's seen as a formality in some regard. You know, when you think about our budgets, for instance, our budget, what we call budgets, are in fact law and appropriation act. An appropriation act is appropriate money and distributes. And the only experience under the First Republic that the budget has failed, which wasn't passed, was once when the E-levy was contested. Meaning that we should have more failures of government executive budget than we see. If not, it means that so many of them have been approved without, in fact, playing the check on the appropriation process.
And these are even where, the guidelines exist and the rules exist that need to be followed.
Absolutely.
But in some cases, are either followed part way or not at all.
Absolutely.
So what happens in this discretionary space where, for example, and let's move on to agencies and the role that CEOs play, where they have the say on how to actually spend. And that's where we have cases being brought, criminal misuse of public funds and administrative mismanagement. What's the difference between those two?
So I'll explain the difference, but I want to give you an example in terms of, because you have talked about the corruption cases. An interesting incident happened where the Attorney General in briefing has claims and alleges that officials at the National Service Authority took the expectation of funding and then went off to collateralize it and borrow money, 30 million, right? Now, my understanding is that this is the institution acting rather than individuals. But no institution has the ability to go and enter into a loan.
And borrow money.
So where then do you get that authority and approval to be able to go do something that only Parliament can authorize you to be able to secure a loan? So that's the first thing. The second thing as well, in terms of what you spend the money on and for. So there's a failure in terms of even on the budget, in terms of the budgetary process. If you look at a lot of the budget that comes to our institutions, you may have a Ghana Police Service that, for instance, has no fingerprinting system. There's no way in which we have a criminal database management that allows people to be able to be flagged. We don't even know and can't identify who are repeat offenders. But when they are presenting their budget, we are more focused on the cars that you're asking for. And so the decision making as to what are you asking for and what the money is to be spent on is also a part of administrative inefficiency or mismanagement in terms of what we're prioritizing.
I'm still stuck on the fact that there's no
absolutely
database.
Not.
There's no system.
No, there's no database.
But your biometrics are captured for passports and the Ghana card.
I have done the police check recently. It shows there's nothing on my record. And I've been arrested more than the average Joe in this country.
And the charges sometimes
and I've been charged with treason
are heavy,
in this country, right? And so it tells you that there's a problem that if we can't be able to, when you're, for instance, even in terms of the natural estates, Galamsey and things like that, when we have foreign nationals who are involved and we say we are deporting, we have no system to be able to determine whether they have been involved.
So they can change names and come back into the country because fingerprints are not in the system.
So that's one of the problems in that regard. But in terms of misuse, the way in which we do this is that for what money has been approved, you have used it for a different purpose without approval. That's one.
That's criminal misuse.
That's criminal misuse.
Okay.
Because once anything there's no approval for has been misused.
Okay, give us some examples.
So, for instance, say you appropriate your requisition money for the purposes of acquiring
an ambulance.
An ambulance, right? And then at the end of the fiscal year, without approval, it is determined that you decided that you pay staff allowances with that instead. You should have gotten you should have requested a change in the approval for what you wanted to use the money for before you do that. Okay, so an example can be the Chachuchikata criminal case, where it was claimed that letters of credit were issued for the Human Rights Project without approval, for instance. Can be an example of how monies that are intended for X purpose or not intended are used for another reason. Another way of misuse can also be in terms of the expenditure that is supposed to be made on the thing, that maybe you have negotiated with a vendor for it to be reduced, and that you guys decided to split the money, right? The benefit of renegotiating it for it to be reduced, or you did it for criminal purposes, for instance.
Okay.
And so that is also one way. There can also be another way in which the money was expended, which did not go according to policy. And by that I mean, where, for instance, a person travels and fails to retire the funds, even though the money was supposed to be given for the purpose for which it was given, a failure to retire the funds deprives the state from knowing whether or not they were used for the purpose for which they were intended for. Okay, so that also happens where, for instance, when you see the Auditor General's report, they can report that there's been losses of 12 million or $12 million or whatever the amount may be. A part of it could be expenditure can be lawful, but how it is operationalized for failure to account can also then count in that
Which
regard.
of the seen right now, the NSA, the Dubois trial, and without prejudicing matters in any way?
So I can only speak to what is in the public domain. Let's take the Dubois case, for instance. The Dubois institutional ends, right? And he says that they were put into a discretionary and secret fund, which we use to cover operational costs. So when you take something like that, even an agency like the spy agency or security agency must follow financial protocols in terms of how they do it. And so if a decision is made without approval and without parliamentary oversight and understanding of where the money is going to go to, and you have used it for those ends, that is a crime because it lacks the requisite approval, irrespective of the fact that you must have spent it on the public purpose, if true, what is alleging is, right? So if you look at, for instance, the witness statement that was filed in that case, the Director of Finance says, I signed it, the check, because I assumed then incur criminal liability, irrespective of that. Then there's also the case, I think in the NSA case, where, for instance, it is claimed that the money was then paid for a number of people on the roll. That is money which is legitimately appropriated because Parliament believed the persons to exist when they were sent. So the money release is actually lawful. Now, if the persons do not exist and you found out as an institution, you're supposed to know whether or not it is for the institutional benefit. And the most glaring one we talk about is where the public funds then exist and it's been used for private ends. That's the one that we talk about, embezzlement and all those kinds of crimes, yes.
And where does it become administrative mismanagement?
So administrative mismanagement might come in terms of value for money assessments. So for instance, value of the road should have been X amount, but then we're invoiced way over that amount. In those cases, we have intended to check that through other administrative mechanisms. One, to limit the practice of sole sourcing in terms of the procurement process. To limit sole sourcing means that you are going to competitive tendering. Competitive tendering then allows you then to be able to bid down and not overstate invoicing. This is why sole sourcing is generally frowned upon. You must get approval then from the procurement authority. So a failure to get approval for that, for instance, then becomes administrative mismanagement. You have used it for a public purpose. We don't know for a fact whether or not the invoice has been stated, but because you fail to follow procedure, we will then presume that the money has been used wrongly. So administrative management is more in terms of procedural steps that have been put in place that have not been followed, because government can overspend. And in terms of even our auditing process, if government decides to buy this bottle of water for 5 million and it's approved and paid, the company to whom it is paid, without proof of any wrongdoing, we can't get the money back from them. It's a contract. It's the government that was not wise enough in managing that. So the only way we can stop that is checking it through the procurement process to ensure that we are not overbilled for that kind of thing.
And we know the challenges that are in,
Absolutely.
Even institutions sometimes presents us with some brick walls. But one of the key parts of conversations around protecting public purse is also discretion.
Yeah.
And discretion can come from different actors in the space.
Yeah.
What role does discretion play in the overall protecting of the actual public purse? Because we've seen governments come and go. We saw the Attorney General at the start of the administration. You know, there's no facts to support winning this case.
Absolutely.
For whatever reason, we are withdrawing it. So the discretion element is a key part of the fight. Where have we missed the boat?
You know, this question of discretion is the biggest challenge to the entirety of our governance system across this. If the right to even override the technical process.
There's a may.
There's the may, that is, so it's across the entirety of all our legislation that even when they are laid down, biggest problems we face across board. But then also in terms of even, you know, in terms of monies that are spent, right, when we're talking about the fiscal aspects, internally generated funds, we allow the institutions to be able to gather money and do what they want with it. And they have enormous discretion in terms of how they spend that money. And sometimes when the fees and charges that we are paying to the institution, so these are Ghanaian taxes that are going into the institution. It's not, you are not making it from selling something, you know what I mean? So a lot of the times how they spend it, even the decision by a public institution that they're going to use those for discretionary funds to go and support a funeral donation. I, for one, do not understand why a public institution would do that. Colleagues may gather and
through a welfare system.
And put through a welfare system, right? But to use public funds for those kind of decisions is also a big way in which money is lost. Then also in terms of what they decide they need and what they decide the money should be on. I have been in a position where I've reviewed priorities across the various ministries. And when you see what they prepare as their annual
and some of the budget
plans and part of the budget items, across and consistently, the biggest ticket items tend to be capacity building. Because capacity building, it's easy to be able to lose money. You are dealing with your own, who is going to bring the food, who you are going to...
Who's printing
this, who is doing the brochure, who is this. All those things are ways in which money is not being spent on core function and programming, but it's spent on these kinds of side things, which allows them a lot of money to be, technically lost. But also in terms of so many ways in which we could check this, is that and this is where the GRA comes back in. Not only the person might go and procure a vendor, and the vendor might say, oh, maybe the vendor actually gave the thing to them at 2,000 cedis on the vendor's end. You can see consistently that if we're going through all individuals that procure services, the state procure services from, they must have a different, because the person is going to account for only the money they have actually received. Taken. Even though they are issuing their receipts like confetti, you can then be able to trace it back to the back end and realize that there's a discrepancy between what this person reported in retiring the funds and what this person is saying in terms of their tax books. And then when you are surcharging the service providers, they then, when they come to you and say, give us a receipt for us to go and write something, would not do it. Because they stand at the risk of losing, knowing that I'm going to pay taxes on 50,000, even though you're giving me 2,000. So that role and the tax role to be able to determine for every instance, even when you find somebody with undeclared wealth or unjustified wealth, believe it or not, they have not paid corresponding taxes. And you can just forget, and like many countries in the US, for instance, they forget the difficulty of trying to go after you to be able to establish that wealth and say, we're just charging you on the fact of taxes not paid. And those can even go higher in terms of the penalties.
Do we have those kind of laws here where people have to declare their sources of wealth?
Yes, absolutely. Political appointees, you're supposed to declare. Yes, when you're assuming public office.
For all of us,
the only way is through the tax system. Because we are required as individuals across board to all be filing taxes. Even if you are employed in the public sector and your taxes are withdrawn at source, you are required to file your taxes. Because once you do file your taxes, you may even get tax exemptions that your employer deducted. Most employers are not taking care of the exemptions, like when you have a child, when you have a person who is in school and all those things. But if you then file your taxes, the revenue person will then return it to. But most people don't do that. But in the tax process, the sources of wealth require whether or not it is an investment, is an income or business.
An inheritance.
Right? So all of that, even in terms of gifts, right, also have the gift tax that you're supposed to pay. So the tax system is the most guarantee for for vetting wealth in any regard.
How do we implement some of these things without it appearing to be witch hunting? Because we've heard this before. Person A is on a public platform and says that, you know, amount of tax. People say, oh, because he belongs to this party, you are targeting him and his business and his you know, financial or commercial activities. How do we navigate politicized? So politicization of perhaps laid down procedures is also a challenge.
I'm a big fan of witch hunting.
You are?
Yes. What I mean by that is it is almost practically impossible to prosecute or investigate corruption when it comes to persons who are politically exposed persons.
Impossible.
It's almost impossible. If you look at, just go back into the number of corruption cases that have been brought in the past against political appointees, more likely than not, it doesn't conclude in conviction. It might go on and drag on forever. A new government comes, they drop those charges, and then a new process starts against former appointees again. They come, they drop those charges. It is now a common joke at the bar, of which I'm a member of, that once a person any person is charged, you can use the technicalities to delay the process and wait till the government comes in. That is what has become the norm in our system. So the bigger problem we face is not that political appointees are being gone after, is that they are never getting convicted. So if we want to review the system, we need to shut the noise around whether you are being targeted and focus on whether or not, how does the process conclude.
Do the courts have those specialized structures to make sure that these things are handled as court and not as, you know, politics?
So that is the expectation, because in the end of the day, you don't speak politics in court. You're supposed to present the court with the facts. The bigger thing is the administrative inefficiencies within our justice system. The fact that the courts are overwhelmed, that when a matter comes before the court, like now we are going to July, if any matter is being sent to court now, the person is not going to see the light of day till October, after the legal vacation comes in. Then, if you can delay to another July, we get, again, legal vacation. So a simple matter can take 5 years, right? It never gets... I give people an example. If you take several law firms in this country, say the law firm has been existing for 10 years, it is more likely than not that the number of cases that they have started, even in the civil system, from the start to the finish, will not be more than 5. I'm not making this up. I own a law firm, and I'm saying that we have not done more than 2 cases, not more than 2 cases from start to finish. It is practically impossible. At the pace at which things go, at the pace at which you might be able to procure witnesses, the state will be able to prepare its defense. In fact, the fastest we have seen in terms of even the prosecution being able to present witnesses before court is in some of the cases that we are seeing the Attorney General prosecute now. Like, for instance, in terms of the Dubois case, the idea that witness statements have been filed already is mind-boggling to me. I was charged with treason, the highest criminal offence the state was made. And every time we'll be going to court, we are saying, when is the Attorney General going to file? Consistently, the matter keeps getting adjourned. So delay is more the DNA of the system. So I am concerned about, we can talk about the big talk, we can talk about the government seriousness around it. But
the political will. That
the process will go into a process whereby, it will be churned and it will go on forever and then it gets discharged. But the question, it comes again back to the question of even discretion in this matter. And when the Attorney General said he was going to explain to the public why he was dropping those charges, some people said the Attorney General didn't even have to explain.
Does he have to consult anyone before going?
Discretion means that it must be exercised judiciously. You can't, it's not on the whims of something. You must be able to tell us what your decision-making process is.
So that's what he's...
said that in the beginning in terms of the cases they discontinued and explain the reasons why they discontinued it. Now, you may not agree with some of the reasoning.
Some found it very controversial.
Some found it controversial.
And
the bigger problem...
convenient, because it appeared to shield members of the now administration who were going through the system. And there were those who thought, well, if they've really not done anything, let the cases continue, let the court actually determine that they have no case to answer. So
in the past, it's never happened. That they just drop it. In fact, there were persons within the current government that were disagreed with the Attorney General in his decision to explain, because they felt that he was opening the Pandora's box that they said. I'm saying, let's open it. The citizens have a right to scrutinize why you are making those decisions. And if we call it controversial, we have a right to, because we can then say that we don't agree with your decision on this. Don't just accept that I have the power and the discretion and I do what I please.
But what can you do if you disagree?
That's the real question. The fact that our courts have determined that Article 296 of the Constitution that guides discretionary power does not apply to the Attorney General's discretion is a big problem for me. So that discretion even goes not only in terms of dropping cases, but also deciding not to prosecute certain cases. The citizens should have the right to challenge the Attorney General's decision not to prosecute a particular matter. So it is important the courts open up the process and say that has that been exercised judiciously, and that's your reasoning makes sense. So for me, it is important that they do that. That is why it is through more transparency and more information that we can be able to exact and know the type of accountability we want. So we can talk about, the Attorney General coming forward and explaining and telling the public, this is the reason why I'm charging them. And I think that it is important because it is even important for us to disagree with him. If we don't have the funding for him to tell us why,
then it's a one-way street.
There is a one-way street. So it is better for us to criticize the Attorney General who comes forward and says this thing than to say that the Attorney General should not even update us at all.
But as it is, is there no challenge or no avenue for challenge to some of the decisions the AG has made? For example, if someone feels that Finance Minister Dr. Kasala still has a case to answer, even after the AG has withdrawn the case, you can't go to Supreme Court, you can't go to...
And that, for me, is a tragedy. But I want to be careful. I do not want to say and suggest that the only way to be constitutionally fair or democratically fair is that the Attorney General must be pushed to prosecute a matter that he no longer believes is absolutely against law. And when Attorney General then, a new person comes into the office, he's entitled to be able to review that. He must not be saddled with well, let's prosecute you to the end. I was part of the criminal process for 3 years. I lost my scholarship at Cambridge because somebody decided that the Facebook post was a challenge. On 2 weeks, I'm supposed to report to the police, and every month I'm supposed to be in court. I can never pursue any private business. I can't travel out for business or do anything. And a citizen's life is at risk when they're put through the process. So it's a huge responsibility when you have an Attorney General who comes then and uses for political vendetta.
Yesterday,
it's a challenge.
We talked to Martin Kwebu about plea bargaining and its role in the justice delivery system. And we asked a question about the innocent in a plea deal. Somebody who has not actually done anything wrong, but prefers, for whatever reason, and it could be many, to accept the plea because then it ends it ends here, and they can move on with their lives. Can you trust a system like that is the question we asked Mr. Kwebu. Perhaps I'll ask the same of you. Can we trust a system that will take an innocent person's plea of guilt just to be, over and done with?
There are 1,000 reasons why, a lawyer might advise a person on an accused client. I would not advise on the plea, for instance, where I have reviewed the Attorney General's case and believe strongly that the ingredients of the offense cannot be established. I wouldn't do that. It's unethical. But when you look at it and you see that there's more chances than not that they could be able to secure a conviction.
Even though he didn't do it.
Because everybody who tells me I'm innocent, I have to take you on your word that you didn't do it. I can only look at the evidence that I'm
innocent until proven guilty.
Yes. So at any point I'm dealing with a client, that's an innocent person I'm dealing with. I can only look at the evidentiary material and say, based on this evidentiary material that I'm looking at, I think it's more likely than not that you could be convicted on the basis of it.
So take the deal.
So that it might make sense. If a good deal is presented, you should take it. Sometimes the weighing of the decision as to whether or not you accept whether a plea should be offered, it also entails a lot of reputational questions that you must ask yourself whether or not I want to do this. I'll give an example. I like to use personal examples. I was presented with a plea. The police arrested me and claimed that I had failed to observe road markings, right? At a place where there were absolutely no road marking to observe. Later on, they came with a plea that just accept guilty and then we'll leave it. And I'm saying, no.
There were no markings.
There's no markings. And I'm not going to accept it for you to go then jump and tout a political point that I pleaded guilty to it. So it must mean that I was guilty. And even though it was a huge inconvenience because every 2 weeks I have to be in court, I did this for the 3 years. So I understand, well, for inconvenience, what do I lose by saying guilty? There's no consequences to it because that's what they plead. They just wanted their guilty plea.
Maybe you should go to Nuchukui. Like you suggested this week. Or
so there's a lot of determination factors that go into it. I think for me the biggest concern people have is one of the things that Attorney General mentioned, which is the non-prosecution agreements that he has reached with certain people.
So they'll give information and they won't serve any time. But they will give enough information to be used to prosecute other people.
And I know that a number of people have started to raise questions about what it could potentially be used for as a shield for political appointees, where then they enter into this non-prosecution agreement. So there's a danger there as well in terms of the plea process and who is offered a plea. We have the same conversation in terms of, and I think it's ongoing, the idea that people are being invited to just refund the money and that's it, I don't think it's fair on the Ghanaian that somebody can then say be accused of stealing 30 million. And the person
they
says,
bring
okay,
the money
I'll just
back.
refund the money and nothing.
And a number of different ways to look at it. There's tell the stress
Absolutely.
of going 3 years
absolutely.
only to determine that Oliver's treason case should not be continued. And we also sometimes get the money back. So you're...
No, I mean, I won't waiting the costs in terms of the blockage in the legal system, the number of prosecutors we have or have to engage to be able to prosecute the matters, and the delays, that a plea bargaining system, and I've negotiated a plea bargain for somebody who was 15 years, was in custody for 5 years. The trial had not even gone anywhere.
Time served.
And we were able to then agree on a plea that an additional 6 months was given, and the person who left.
Okay.
So there are advantages to the system that you can get, but there are also dangers.
I wanted to pick your thoughts on trust in the, the public system of, retrieving or protecting the public funds and people's perceptions that perhaps political will is sometimes lacking in some of these things. But the OSP has also been quite big in we have not been written to officially. We are also seeing this on social media and all that. If you were OSP for one day, what would you do?
I'll need more than a day. But I think that if I was OSP for a day, I would charge Nuchukwi. But
we should go and swear.
that's on a lighter note. I mean, I think that you talk about political will, and come back to the question, that one of the reasons why the OSP's office was created with regards to Kenneth Oriata were matters that happened way before even elections. And so that if you claim that you have been investigating for that long, the purpose was that your office is supposed to be so insulated that you can go against sitting officials. In fact, corruption is committed by current officials rather than the people from the past. Right? So it is when the corruption is happening that
you should get them.
That you should get them.
Not after they've spent 500 plus billion.
Whatever times. In fact, even everybody else, I've even argued that perhaps it doesn't even cover the vice president. So the extent of what you can do while you are in office is where your mettle is shown, in my opinion. So there are certain lapses that we've seen in terms of the OSP's this thing. Unfortunately, I think that even when you look at the public sentiment now, more people believe that Yoko, for instance, is doing a better job than the OSP is doing. And that belies the assumption that the OSP is more independent and should be doing better in the role. And therefore, how many years we have put the institution in place, for the monies we have spent on it, people feel like we're not seeing the returns. I mean, every public institution must justify itself by return on investment. Ghanaians feel like we're not seeing the investment that is needed. In my opinion, I do think that the OSP needs a bit of restructure and rethinking. I think they need to do a bit of step back. There was a whole conversation, a number of press conferences the OSP gave, seemingly attacking the judiciary or blaming the judiciary on things that people thought was not wise, particularly wise in terms of how they went about it. I think when they reflect back on it, they may say that some of those things were not necessary at some point. I think that the State of the Nation address types, dramatic press conferences, it's a bit too much.
But the AG has done very similar, also addressing the public and bringing facts and details that the public would not
I'm in love with public transparency. And in a long time, it becomes like a gimmick that people don't continue to take you seriously.
You still haven't told me what you do in a day as OSP.
I'll advocate for the expansion of our prisons. That's what I'll do in the first day.
Expansion?
Yes, we need to expand the prisons.
Are you anticipating more people to
I am anticipating more people, but it's already so overcrowded. I mean, I am a person who believes that more people need to be jailed, but also believe that people who are jailed their human dignity needs to be preserved. So I think the OSP, because for what is going to happen, we need more prisons.
Oliver, I wish I had more time, because what is going to happen is the question that I would ask next. Do you have information that for?
I mean, I have said that we haven't. Listen, at this point, we are still at low-level officials, and the Ghanaian public is shocked in terms of what some of the things the Attorney General is talking about. But some of the people and some of the issues that have been investigated, I think that we all have to hold our breath. And I do want to see more of the OSC stepping up and taking up more of these cases as well, more generally, to complement the
even
work.
If they are out of our jurisdiction, like in the case of Mr. Oforiata.
Even when they are out of our jurisdiction. And the question of the jurisdiction, I have said this before, that in the case of Sedna Tamaklo, who is outside of the jurisdiction, was convicted in absentia, I think it undermines the government if we don't see the same level of seriousness in trying to bring her down. It's those kinds of things that will quell allegations of political witch hunting, that where persons you're not seeing the same level of aggression in trying to bring her down. Even though there are persons who are affiliated with her and associated with her and charged together who are currently in Sawam, that we need to take efforts in that.
So, like, long story short, is this system protecting the purse, or has it been, I don't want to say hijacked or bypassed, or is it being bypassed by politics and politicking?
No, the purse is long gone, to be honest. We're trying to find the purse.
The purse is gone.
The purse is gone. We're trying to find the purse because the purse has been unguarded, right? And there's so many levels in which, we lose it. So in that respect, I think that what we are trying to ask for, particularly in terms of the conversation around oral, is that we need institutional measures. I've talked about we need law reform that I'm not seeing as part of the oral conversation happen. We need institutional restructuring. We talked about complementarity and collaboration, for instance. I believe that we can reorganize some of the institutions. We can join the OSP and the YOCO together as one institution, call it the National Prosecution Authority, for instance, as Ace and Kuma has suggested. We can reorganize the institutions better and retrofit them.
Some people are saying independent public funds prosecution unit or a financial crimes court.
I think the court, for instance, we definitely need an independent court that allows these things to go forward. There was an attempt with the fast-track courts, which then got bogged down in conspiracy and political hand-wringing. But we need a specialized court. I've been in the court, and I tell you that if they're going to follow the same timeline, nothing is going to happen. They need courts that are dedicated specifically to these things.
Oliver, thank you. This is education for you, telling us exactly what the roles of the institutions are and some of the roles of the actors and players within that space. Oliver Barker-Vormawor is a lawyer and he's also an activist, and he shared his thoughts with us on the show today. Thank you for making the time. Thank you as well for joining this program today, Wednesday, and we'll leave you now and we'll see you sometime tomorrow in the morning. For now, enjoy the rest of your Wednesday and be safe out there. See you.